Okay, we're here. Mr. Lang, I think you're up first. Yes, you're up first. Do you want to reserve 5 minutes?
Yes, Your Honor, please.
Okay. All right, we're ready whenever you are.
May it please the court, Joseph Lang from Carlton Fields for the Hadleys. Quite simply, this case settled. All of the conditions that were set out in the demand letter presented by the plaintiff's counsel were met, and they were timely met. When the Hadleys then moved for summary judgment to enforce that settlement, the trial judge, based on documents alone, this is a documents case, this is a contract construction case, based on documents alone, the trial judge denied summary judgment on one reason. And that one reason is that the affidavit of coverage, the judge determined as a matter of law, was insufficient. There are no factual issues to still
Well,
be.
Mr. Lang, that affidavit on that point is concerning because the whole idea, the whole purpose behind that request was to make sure there wasn't any other policies out there, and the requirement that there be some investigation. I mean, they basically said that a claims man for Geico investigated whether they have any other policies. I mean, that's kind of legitimate. I mean, you know, that's the whole reason they wanted to know that. I mean, you checked and there aren't any, as opposed to we don't know about any at this time. It's pretty vague, pretty concerning. So it doesn't look like it meets the mirror image, both in the spirit and the intent of what was asked for.
Well, Your Honor, it does say none known at this time on the affidavit of coverage, and it references that they got that from the policy declaration was determined from the computer records of the company, which would be the natural place to look. But more than that,
I don't think we know that, though. Is that in our record that we know that?
On the affidavit of coverage, it says at the bottom of it that the policy declaration was ascertained from the computer records.
Okay.
Recreated based on records in our computer data files. And so are you contending that was the question to the answer to the question that Geico has investigated?
Well, I think that is an investigation. I think the plaintiff will tell you, but out of candor to the court, I will tell you, this affidavit was actually signed a few days after the demand letter and before Geico even received the demand letter. Geico received the demand letter on March 12th. This is a standard form that is generated as soon as a claim is identified. And so the investigation was done in the computer records and no insurance was identified, but this wasn't particularly aimed at the request about an investigation because that letter wasn't even obtained by Geico until a few days after this form was.
So checking Geico's own computer records constitutes an investigation?
Well, I would say, Your Honor, that's the first thing they did. And I think that's the best place to look because that's where Geico would have access to any information that they have in the company as to other coverage. But
Mr. Lang, I don't know about you, but I thoroughly trust everything I read on my computer.
But they did more than that, Your Honor. They did more than that. And I think this is critically important. The next place you would go if you were doing an investigation is to your insureds. And you would ask your insureds, do you have other coverage? And what did Geico do? The adjuster had to facilitate the insured's affidavit. So the adjuster has to go to the insureds and ask the insureds, do you have other coverage? And the affidavit of the insureds was prepared and it says they have no other coverage. That's the best place to go after you look at your own computer records. You put those two things together and Geico has done an investigation.
Could you, just before we forget, could you talk about jurisdiction?
I'd be happy to. Thank you, Your Honor.
Yeah, good
Yes. You asked us to be prepared to talk about Jackson and Powell. As Your Honor knows, we cited Powell in our reply brief. It came out in the interim after our initial brief. Starting with Jackson, Jackson obviously has some broad language in it as to magic language and orders dealing with immunity. And right out of the box, our order does not have that magic language. It says summary judgment denied. But our order also doesn't have the language that the order in Jackson had, which on the face of that order, it says there are summary judgment is denied because there are disputed issues of fact. And so the court actually makes the observation in Jackson that your theory of jurisdiction, department, is actually contrary to the face of the order. Here, our theory of jurisdiction is completely consistent with the face of the order because this order was determined on a single point of law. It's not going to change going forward. There's not further discovery to be done on whether this affidavit of coverage is sufficient or not. This judge has determined on page 188 and 189 of the appendix that this affidavit is insufficient, this affidavit of coverage. That is not going to change. That is a determination of law, and that is a determination as a matter of law. I will also note that the Florida Supreme Court in Jackson, despite the broad language about magic words in an order, it actually references that they went and looked at the record. And in the Jackson opinion, it says, we can't find anything in the hearing transcript that expounds upon the reasoning. Here, you don't need to go and do a searchlight, as the word has been used in the workers' comp cases. You don't need to use a searchlight and go investigate under rocks to find out what this judge ruled. He ruled one thing, and he ruled it on page 188 and 189, and that is that this affidavit of coverage is insufficient as a matter of law, and therefore there is no settlement.
So the discussion we just had was whether the response that said none known at this time, and then the inference we can draw from other parts of the response that, you know, the insureds were asked, whether that constitutes in a response to the request to disclose whether an investigation was done. That's a purely legal question, and this was purely a decision on made as a matter of law by the trial court.
Yes, Your Honor. And that's the only basis he ruled on, was whether the face of the affidavit of coverage matches up with the face of the demand, which asked for an investigation. And he says the face of the document, it's contract interpretation. And so the danger that Jackson is worried about, which is people taking appeals of non-final orders when really those cases ought to move forward for more factual development, that danger is not present in this case, because this has been determined as a matter of law. You know, unless the judge has a complete change of heart as to contract interpretation, no amount of factual development is going to change his view of the affidavit of coverage.
Can you give me an example of a, let me ask a question. I'm not above asking dumb questions, but I just want to make sure we're all on the same page. This is what your jurisdictional argument is based on, the supposition that as a matter of law, the court found that a settlement agreement never existed. Yes, right? In other words, that there was never an acceptance.
Yes, Your Honor.
That falls within never existed, the meaning of never existed.
Yes, Your Honor.
Okay, so so as a matter of law, could you give me an example of a scenario in which the trial court could find that a settlement agreement never existed and it not be a determination made as a matter of law based on the face of the, you know, the offer and the supposed acceptance?
Yes, Your Honor. Powell versus Woodard is a great example. That's the first district case, which is the first appellate case under this new rule. Obviously, Jackson is under a sovereign immunity rule. This is under the settlement enforcement rule. So Powell versus Woodard is the first case under this new 9.130 rule. And in that case, what the court says is we look at the record, and even though the judge denied enforcement of the settlement, it was after 2 days of hearings with testimony and argument of counsel. And basically, I don't see that
Well,
you
what,
have
didn't that what happened here?
not testimony. This is on the documents. We had argument of counsel, but this is purely on the documents.
So what kind of testimony do you think was adduced in Powell versus Woodard?
Well, if you'll allow me, this is not in our record, but I think it's public record. I went and actually watched.
From the face of the opinion in Powell versus Woodard.
Right. I was going to say, I watched the oral argument and it gives
From the
some
face of the
insight.
opinion in Powell versus Woodard.
It says testimony. That's
Okay.
all 2 days of testimony and argument of counsel.
Okay. Any other, and that's why I was asking, as a matter, maybe a hypothetical case, or, under what circumstances would there be a, well, I think you understand my question, but.
And another example, I think Powell versus Woodard is a great example because it's much different from our case. But another just example in the air is when the offer is oral, when the offer, instead of a written demand letter, the offer is back and forth over time between counsel. What would you think if we offered this? A counter offer, back and forth. To enforce that settlement, it's going to take a lot of testimony as to how the state of affairs came to be. Here, all we have is documents. We have a demand, and then we have an affidavit of coverage, and we have an affidavit of the insureds, and we have a proposed release. Those are really the documents at issue. Any other questions? I'm happy to talk more about jurisdiction. I would make this request, though. If the court doubts the jurisdiction, and I really don't think there should be any reason to doubt it, I would ask, having briefed this whole case, and I suspect plaintiff's counsel may agree with me on this, that you consider relinquishing jurisdiction back to the trial judge, just so he can write some magic words in, because I think we agree, I think plaintiff will agree with me, I'll find out, but I think everybody agrees the judge found the affidavit insufficient as a matter of law. I don't think anybody wants to go back and do this hearing again or do more discovery on this issue. And we would ask you relinquish jurisdiction for 20 days, 30 days. Let us get an order that has the 2 or 3 magic words, which I think are evident on the face of the transcript anyway, and come back to you and let you decide this case on this briefing. I would then just talk about, that's all the judge ruled on. But in the answer brief, we have some other arguments, so I'll address them very quickly. There's an argument that the affidavit of the insureds is not sufficient. And that argument touches on one of the things that is said is that the affidavit of assets is vague or hard to understand.
Are we confined to the one issue that the trial judge seized on? The trial judge seems to have seized on this issue that we've discussed thoroughly now, and not the rest of these things. Am I right on that?
Trial judge did not address any of these other issues.
Yeah. So are we then confined to the one issue that we've talked about?
I think as a prudential matter, you should confine yourself to that. I suppose you could look for alternative bases for affirmance, but I think as a prudential matter, as a matter of fairness, the trial judge did not address this in the first instance. And I don't think that and I think on their face, these are invalid arguments.
They're certainly nitpicking, aren't they?
Yes, Your Honor.
Okay. I mean, whether they're invalid or not, I'm not sure, but they're kind of falls in the category of come on, right?
Yes, Your Honor.
Okay.
Well, with that caveat, with that agreement, I'll reserve the rest of my time for rebuttal.
You've got 5 minutes. Okay. Mr.
Your Honor, good
Trujillo,
morning. Thank you.
how are
Your
you,
Honor.
sir?
Thank you. Good morning. My name is John Trujillo. I'm appearing on behalf of Mr. Dowling for purposes of this appeal. May it please the court, counsel. The first thing I'll state is that I do not agree with Mr. Lang that this court can relinquish jurisdiction back to the trial court for purposes of holding essentially a rehearing or reassessment of the pattern of the order that's already been entered. For the simple reason is because I don't believe that this court has jurisdiction actually to hear this appeal, and I would move for this court to dismiss the appellant's appeal.
Mr. Trulio, I've gone back and I've read the transcript. Do you agree that the trial court made a ruling that he found the affidavit insufficient, as Mr. Lang has suggested?
Yes, if I may explain. I believe that the trial judge found that the affidavit was sufficient, but the appellant's entire argument here is based on a faulty premise. And that faulty premise is that Judge Walker's findings were based solely on the affidavit of coverage that was executed by Mr. Doucette, I believe. If the court will look at, and I realize you won't do it right now, but appellant's appendix number 191 is page 31 of the trial court hearing transcript.
What line? What line? We have it.
Thank you, Your Honor. Line 12, page 31, line 12, beginning with the word but. And Judge Walker says, but I have to look at what is before me. And it would be inconsistent with my understanding of the law if I were to say that under all the circumstances that have been presented in these proceedings, that I were to grant your summary judgment, which is an indication that Judge Walker was listening to the 7, 8, 9 points that I raised in support or in defense of our motion.
Okay, so Mr. Trulio, trial judges, when they're hearing both arguments, they may not have made their decision at the time of the hearing, but then at the end, the judge asked for a proposed order of the arguments that were made. And there is no, from what I can tell, there's no specific ruling that is laid out by the trial judge other than the request for a proposed order. And until that trial judge actually signs the order, the judge could change their mind, right?
Is that the question, whether or not the trial judge can change their mind?
I'm looking at the transcript for like specific findings, and here you have, I agree with you, you have that language, and clearly the judge is listening to both sides as it's discussing what the arguments are laid out before the court at this point in time. But until the judge actually signs an order, the court could change their mind from the point in time of the hearing until the proposed orders are submitted, and may even reject, some of the language of the proposed orders.
Yes, Your Honor, I understand that. And if I may respond to that. On the very next page of the transcript, which is Appellate's Appendix 192, page 32 of the transcript itself, beginning with line 8, I asked the court, for purposes of the record, the motion for summary judgment is denied, Your Honor, ? Answer, yes. Thank you, Your Honor. Then the order is simply entered in accordance with this language. So I think what is apparent from the record, Judge Smith, is that there was a record of the 6, 7, 8, 9 issues that we raised before Judge Walker that should have and did defeat the plaintiff's or the defendant's motion for summary judgment, all or any of which would have been a legal basis to find that there was no mutuality of assent, that there was no meeting of the minds, and that the defendants in the case simply did not prove their case on motion for summary judgment. I understand that the bar is very high, and I know that the panel understands that the bar is very high. But what we have to begin with is what Judge Morris first asked about at the inception of this proceeding was, isn't the affidavit that was initially delivered by Geico insufficient in some regard? My answer is yes, it is, because what did Mr. Arcaro, Mr. Dowling's initial attorney, ask for? He asked for a verification that, quote, no other available liability policies to cover this claim, unquote, was in existence. That is at Appellate's Appendix number 107. That's his March 5th, 2018 letter to Geico. So what Mr. Arcaro is asking is for Geico to verify, not look at your own computer records, not see what you have in your own files, because that assumes that there wouldn't be no other potential policies out there, which is exactly what Mr. Arcaro is trying to determine. He did not get that in response. All he got in response from Geico was a very equivocal, as referenced by Judge Atkinson, response that there were, quote unquote, none known at this time. Mr. Lang says that Geico did investigate, that the adjuster did investigate by asking their insured, were there any other insurance policies available? There's nothing in the record that shows that that actually occurred. And in fact, at appellate's appendix number 58, this is a fax cover letter from the Geico adjuster to Miss Elizabeth Hadley, one of the insureds, where the adjuster simply says, hey, sign this affidavit. He doesn't ask the question within this fax cover sheet. There is no other independent verification that Geico did any investigation other than look at its own computer files to determine whether or not Geico had any other policies that would have inured to the benefit of the Hadleys. I don't think I need to tell the panel the importance of understanding whether or not there is other insurance coverage. If you look at this from Mr. Arcaro's viewpoint, he's got a gravely injured man that's lying in the hospital at this point. He has to do everything that he can without filing suit to determine whether or not there's going to be any other insurance coverage to compensate this man for wages, for loss of income, pain and suffering, medical bills, of which they were mounting and are continuing to mount. Because what happens to Mr. Arcaro if he agrees to release these people without an absolutely verifiable indication that there is no insurance coverage? It's possible that he gets sued for malpractice, and then his client is left twisting in the wind. If I may move on to the other infirmities of the acceptance of this offer, there were several. First and foremost, and this has sort of been glossed over and not addressed at all by the appellant in this case, and what I raised in the motion for summary judgment hearing was that the affidavit from the insureds was never delivered to Mr. Arcaro. Mr. Arcaro asked for an affidavit from the insureds indicating that there was no other insurance coverage, indicating that they were not in the course and scope of their employment. And he asked that that affidavit be signed by all of the insureds, Ross, Elizabeth, and I believe I'll use her initials because she's a minor, KE, who was the driver of the car at the time. If you look at appellate's appendix number 57, this is a copy of the actual affidavit that was allegedly executed by the Hadleys. The first and most glaring deficiency in this affidavit is that it's not signed by Ross Hadley, who is he's the father, and he's identified as one of the insureds on Geico's deck page. It's not signed by him. So therefore, that leaves the potential that even though Elizabeth and KE signed this affidavit and said there was no other coverage, that Robert out there is hiding in the bushes, but he could have assets. He could have been in the course and scope of his employment, but keeping in mind that Mr. Arcaro didn't know what, if any, Ross Hadley's involvement had in the accident as of the time that he had requested this affidavit. So that's the first problem with the affidavit. If you actually look at the fax legend at the top of appellate's appendix number 57, it's got a date on it, apparently a date from transmission, and apparently it's got a time of transmission. It's military time, 3:02 in the afternoon. But like I told Judge Walker, Judge, where's the evidence that this was actually delivered to Mr. Arcaro? If you look at Mr. Doucette's affidavit, he's the actual adjuster. His affidavit is found at appellate's appendix 40 through 41. Mr. Doucette says, on March 15th at 4:41 p.m., I transmitted via email to plaintiff's counsel the signed financial affidavit by the Hadleys. Then he also says on March 14th, he transmitted an affidavit of coverage via email at 8:14. And on March 15th of 2018, he transmitted the insured signed financial affidavit via email at 4:42 p.m. Well, first of all, none of those times match the fax legend on the affidavit at appellate's appendix number 57. And secondly, does Geico mean to tell me that if they faxed and emailed something, especially of such critical importance to a plaintiff's attorney regarding a serious and gravely injured individual, that they can't prove to me and they can't produce a fax cover sheet? They can't show me a receipt of a sent email? So at this point, there is absolutely no record evidence that Mr. Arcaro ever received the signed financial affidavit by the Hadleys. As this court already knows, pursuant to second DCA case law, an affidavit in support of summary judgment may not be based upon factual conclusions or conclusions of law, which is all that Mr. Doucette is saying in this affidavit. I sent it to him, but there's no substantial competent evidence to prove that. A statement of ultimate fact will not justify entry of summary judgment. Both of those statements come from the Land Development Services versus Gulfview Townhomes case, which is a second DCA case from 2011. The additional issues which show that there was never a valid mutuality of assent or meeting of the minds, whichever standard the court prefers to to focus on is the presence of the release that the adjuster sent to Mr. Arcaro. And listen, I will recognize that it's pretty obvious under Florida law that some sort of basic, and I focus on the term basic, release should be expected by a plaintiff's attorney under these circumstances. I'm not going to quibble with that. Even though Mr. Arcaro never requested a release, I think the third.
But if the defendant said, you know what, doctor it up however you want, is that a counteroffer, or just saying, hey, let's move things along. Here's a release.
Judge
fiddle with it if you want.
Yes, sir, Judge Atkinson. I'm really glad you asked me that, because the case of Villarreal versus Aris, which is a second DCA case from 2013, had this same sort of scenario in it. The site for that case, Your Honor, is 128 Southern 3rd 93. And I quote, "An offer to alter release language is not sufficient to create a binding acceptance," unquote. Judge Morris was on the panel at the time that opinion was written. So I believe that the question to your answer is no, Your Honor. Not to mention the fact that in the release itself, the release, the cover letter that was transmitted with the release creates some additional terms with the release. First and foremost was the adjuster, Mr. Doucette, asking Mr. Arcaro to quote, and this is at appellate's appendix number 53, Your Honors. It's a March 13th, 2018 letter. The adjuster asked Mr. Arcaro to quote, "not disburse the proceeds of the settlement until all liens are satisfied." He also, the adjuster also requests that Mr. Arcaro, quote, "have your client sign the enclosed release and return this release to Geico as soon as possible," unquote. These are additional conditions that Mr. Arcaro, number one, never agreed to. There is nothing, if you are truly taking a mirror image approach to this case, you have to look at the what, not the why, right? It's what did Mr. Arcaro request? What did Geico give him? Did Mr. Arcaro ever agree to do any of these things? He did not. He did not agree to hold on to the proceeds of the settlement until the liens were satisfied. That presents all of these additional conditions, present practical issues for a plaintiff's lawyer who's got a severely injured client laying in the hospital. If he cannot disburse the money to his client, who is the guy that needs it the most out of anybody in this scenario, then that presents a problem. But legally, it presents a counteroffer. The release itself also releases all claims against the Hadleys. And if Your Honors will focus on the amount of money that was actually tendered by Geico to Mr. Arcaro, it's important to note that Geico only tendered $10,000 of bodily injury proceeds. There was still a property damage claim that was out there, that was pending, in which Mr. Arcaro had raised the issue of with Geico throughout his previous correspondence with him. So if Mr. Arcaro signs this release and releases the Hadleys for everything, now Mr. Dowling's motorcycle ain't going to get paid for, which is just rubbing salt into the wound, but also acts as a failure to accept legally pursuant to the mirror image rule. One last issue that I'd like to raise about the release itself, two more, excuse me, is that the release requires Mr. Dowling to satisfy, quote, all liens, unquote. I raised this issue with Judge Walker at the motion for summary judgment hearing. The problem with agreeing to satisfy, quote unquote, all liens is that anybody that provides services to Mr. Dowling in care or in treatment of him as a result of this accident could assert some sort of lien against his settlement proceeds. It is not a valid lien unless there is or was a letter of protection that was executed by Mr. Dowling in favor of that provider. So what that means is practically is that if Mr. Arcaro signs the release, he's got to agree to pay anybody that makes a claim on the settlement proceeds, even if they don't have a legal right to do so. Secondarily, the release also releases the Hadleys from any claims for subrogation. And that's not the most least important thing here. The effect of that, which was addressed in the Villarreal versus Aris case, second DCA, is that this is essentially a hold harmless indemnity clause that was contained in the release. And it says that, and what it ultimately means is if Mr. Dowling agrees to this release, he's released the Hadleys. But on the other side, Mr. Dowling has medical providers who have a technical and legal claim for subrogation against the Hadleys because they caused the damages that the insurer paid for. So theoretically, what can happen is if Mr. Dowling signs this release and agrees to release the Hadleys from subrogation claims. He takes the $10,000 from the Hadleys. His insurer or insurers then turn around and sue the Hadleys to be compensated for what the insurer paid in medical bills. And the Hadleys just come right back and sue Mr. Dowling for whatever judgment is taken against them in subrogation. No plaintiff's attorney in this state that is worth his or her salt is going to agree to a provision like that, because it potentially takes a guy that's laying in a hospital bed and puts him in a much worse situation legally and potentially cancels out the settlement. So for all of those reasons, Your Honors, I think it's very clear that there absolutely was no meeting of the minds. There was no mutuality of assent. All of these issues gave Judge Walker the clear legal ability to deny the plaintiff's or the defendant's motion for summary judgment. And I would ask you to affirm Judge Walker's summary judgment here today, provided that it reaches it past the jurisdiction question. But as I said at the beginning of my presentation, I do not believe that this court does have jurisdiction to actually render an opinion on this matter based on the very clear language of Powell versus Woodard in the FHP versus Jackson case. But I'd be happy to respond to any questions on jurisdiction or the remainder of my presentation.
Any questions for Mr. Trujillo? Okay, thank you very much, sir. Mr. Lang, you have 5 minutes.
Yes, Your Honor. While I disagree that the judge's basis was any broader than the affidavit of coverage, as a jurisdictional matter, even if he based it on other parts of the affidavit of the insureds, the release, or the affidavit of coverage, they all are based on documents. It's
What if it was
contract-
based on the untimeliness issue? Would that be as a matter of law, or would that be?
No, I believe that is the only issue. Yes, Your Honor, that's a great point. That is the only issue in this case that could create a matter of fact, but the record disproves this. You can see in the answer brief, you can see in the memo below that Mr. Dowling has admitted receiving parts of his counsel have admitted in these various charts they've included below and in the answer brief that they received parts of what's in the insured's affidavit, but not other parts of it. But it's a single affidavit. There's no way that they received the part that talks about course and scope of employment and did not receive the other parts of the affidavit. And in their chart, they say that they received an inadequate answer.
Can you remind me? This is I need reminding that chart. You're saying that chart has to have been based on receipt, a timely receipt, as opposed to some subsequent time when they obviously got to see what you said you sent. That makes sense? Probably not.
No, I think I understand, but I think they're making the point in the chart as to what is inadequate.
But you're saying because they put a chart in their answer brief, months after the fact, that they're conceding that they received it timely?
Well, I think that it indicates that they did get it. I understand Your Honor's point. That may not be conclusive, but it certainly indicates what their point of view is as to parts of the affidavit and not as to other parts of the affidavit as to whether they received it. They don't make a specific note in that chart that all of this was untimely. So I would say that the chart at least acquiesces through silence as to this part was received. But I do acknowledge that the timeliness issue could be an issue of fact if the court does not agree that the plaintiff has acquiesced that they received timely the affidavit. Everything else is based on the documents. As a jurisdictional matter, though, I want to make sure that I'm clear that everything but for that issue we just discussed would have been decided as a matter of law. So I think whether the judge decided it on one basis or 5 bases, they all would have been as a matter of law. And if the court thinks they need magic language in the order, I would ask you to relinquish. Obviously, the court does have inchoate jurisdiction to relinquish to get a better order, even if.
But we may have that jurisdiction, and I could ask, more experienced judges about that inchoate or you said inchoate, inherent, I don't know. But does the trial court have the jurisdiction if we did relinquish ours to what, under 1.530 or 1.540, what?
It's
This
a
long
non-final,
after?
it's a
Is
non-final
this
order.
a judicial, what's that?
It's a non-final order, Your Honor. It's an order denying summary judgment, so the case is ongoing in the trial court.
Well, that's a good point.
Without a relinquishment, the judge should not overrule an order that's on appeal, even if it's an interlocutory order. That's why I would ask you to relinquish your inchoate jurisdiction back to the trial judge. But at that point, the judge could amend his order if you relinquish your jurisdiction to add the few words that would be needed if the court thinks those are needed. I don't think that's needed for you to adjudicate this appeal. Real quickly though, before I'm out of time, I do want to
But
about-
another point would be if we don't have the jurisdiction because of what was on the face of the order, or then why would we relinquish it? Why wouldn't we just dismiss it? And then if the judge then amends his or her order, then you could appeal that.
judicial efficiency, case is fully briefed.
Cost the parties money.
Instead of being back up here 6 months from now, starting briefing again after we go back, case is fully briefed.
Mr. Lang, you've got 5 seconds.
Okay, on the release, it's a standard release. Why in the world would an insurance company pay the policy limits if they were not going to get a standard release and not get liens released, which is standard release language? And you can find that on page 56 of the appendix, paragraph 2. You'll see it's just a standard release of liens language in the proposed release. Thank you. I would ask you to reverse and remand.
Thank you both very much. I appreciate your arguments. You both did a fine job. Thank you.
Thank you, Your Honors.
Thank
Good
you.
day.